to bring in the files. I'm going to issue a warrant.
Okay.
Second one's not till.
What's that?
The second one is not set till 9:30.
Okay. Well, at least as to the one. Your appearance?
Good morning, Your Honor. Jeff Osmond on behalf of John Hudson.
Your name, sir?
John Hudson.
Detective Lieutenant David Tiller, Whittier.
So we have, I believe I did the signing on record on this. I don't remember all the specifics. But it was capturing or distributing an image of an unclothed person at 19940 West Road in Woodhaven, and using or installing a device at that location, eavesdropping, and then we also have assault resistant obstructing officer. So we have a 5-year and then a two-year felonies respectively. Does he stand mute? Wait, formal reading?
Yes, sir.
I'm going to advise you of your rights, Mr. Hodgson. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. Also, if you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, if it goes that far as to each one of these counts, the people have to show that the crimes were committed and that you were the one who probably committed the crimes. If they prove that, they'll be bound over for further proceedings to the circuit court. If they fail to prove that, this case would be, as to any one count that they can't prove that as to, that would be dismissed. Do you understand that?
Yes, sir.
Probable cause conference is going to be August 19th at 9:30. That will be in front of Judge Hessen. August 19th, 9:30. Preliminary exam, August 26th at 11 a.m. in front of Judge Hessen. I'm going to listen to bond. Can you quickly refresh my memory? What is, Detective Toller, what is 19940 West?
That is Panera Bread, Your Honor.
Okay. Remind me just real quickly what happened here, allegedly.
It's alleged that a customer had observed this subject right here before us walk into the women's bathroom. She recognized the subject from going to high school with them, knew that he had previously possibly been charged with a crime of the same type of incident we're talking here. She went into the bathroom directly after. That's when she located a pen that turned out to be a camera with an SD card in it. She pointed out the subject to officers. He was located, and that's when he took off running and resisted the apprehension, allegedly.
Was there a prior
Buckle up, everyone, because today's courtroom session is packed with everything from hidden cameras to resisting arrest. Surprise breathalyzer results, interpreters who don't show up, and a judge rapidly losing patience. We're talking felony charges, bond debates, prior convictions, and emotional pleas from defense attorneys. And as the tension resides, so does the judge's frustration, especially when defendants show up late. Ask for adjournments or push the court's limits. Watch closely, because the decisions made in this courtroom will impact multiple lives, careers, and criminal records. Let's dive in. This one gets intense fast.
conviction for a similar?
I didn't handle the case, Your Honor, so I don't know firsthand.
All right, what would you like to say?
Judge, when this incident occurred, we've been monitoring it. When the warrant came out, we made immediate arrangements to get him arraigned before the court. He is employed by GM, builds transmissions for them in Toledo. He is a resident of, is it Taylor? Trenton, Michigan. To the best of my knowledge, never failed to appear for court. He's been cooperative with me. And as I indicated, once we found out the warrant was issued, made immediate arrangements to get him arraigned on, and he walked in here today. I'd be asking the court for a PR bond with whatever conditions the court appropriate, but with permission as well to at least travel to Ohio to the GM plant for one. And just so that everybody knows, after my conversation with him, I am going to be submitting for a forensic review. So I don't know if I should send that to Judge Hessen, because that's where the next court date will be.
Well, I think you could probably appear by Zoom
Okay,
and request the forensic then. Should be probably done with you speaking to the prosecutor first, and then if they don't agree, you can argue it. They usually do. Do you have anything that you want? Are you asking for any kind of cash bond?
No, Your Honor.
And what kind of conditions are you asking for?
Your Honor, I would just ask that the subject be asked to stay away from Panera Bread. Any potential witnesses in this case, but other than that, nothing else.
$10,000 personal bond. You cannot leave the state without the consent of the court. You can leave the state for employment purposes without consent. You cannot violate a law. You must appear in court as directed. The PCC again will be August 19th at 9:30. No contact with Kylie Magyar. You cannot write, phone, see, text, email, or communicate with her or have anybody else do any of those things for you on your behalf. No contact with prosecution witnesses except through your lawyer. You're not to enter or go near 19940 West Road in Trenton. Wait a minute, or that's Woodhaven rather. Woodhaven or any other Panera Bread store. You're not to distribute, and then I got to be careful the way I'm saying this, not to distribute any captured images of this or any other business or any other businesses, I should say, private areas, which would include bathrooms, okay? I'm not saying he has them, I'm not saying he doesn't have them, but he's not going to distribute them, okay? Anything else?
no, sir, thank you.
All right, so do you have anything else?
No, Your Honor.
And he has been printed, right?
I believe so.
He is arrested.
Yes.
Let me just double check here. Yes, he was printed. Okay, and I got the bond sheet filled out. You can go down the hall and you're all set. Good luck, thank you.
Thank you, Your Honor.
Richard Allen Hanley Jr., 25W838922.
Good morning, Your Honor. Jordan Goldberg, the 87047. I'm standing in for counsel of record, Steve Sharp, on behalf of Mr. Hanley. Mr. Hanley's consent. Is that correct? Yes.
Your name, sir? You.
Richard Allen Hanley Jr.
Okay, so this was a OWI from July of 25. He looks like he had one in 20 and, or no, it looks like the one from 17 was dismissed.
That's correct.
That was out of 24th. What allegedly was the breathalyzer blood draw, 151? Okay, so he stands mute. Anything you want to say regarding bond?
Yes, Your Honor. Mr. Hanley is a single father, works full-time as a diesel technician and mechanic at National Tank Service. He has sole custody of his handicapped son. He's 19 years old. We ask that you give him a personal bond. If you're not inclined to do that, we'd ask for a modest bond with a 10% option.
Sir, $2,500 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to attend ANA twice a week. We're going to give you a form. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You are to be on a SoberLink device by the end of the day. Probation will explain that, how you go about acquiring that. That's a machine you're going to blow into. And so you'll be on that by the end of the day. Those are the bond conditions. We'll give you a court date. Counsel, or Lisa, what do you have for me?
September 3rd at 9 o'clock.
Okay, is that good?
Thank you, Your Honor. Yeah.
That's a good day?
Yep.
Okay, September 3rd at 9 a.m.
Your Honor, where will he go?
He's going to go over to probation, and they're going to explain how he's going to go about acquiring that, okay?
Thank you, Your Honor.
You can first go down the hall, get your notice, and then go back across the hall. Thank you.
Thank you.
Do I have, did you take care of that McCullers file?
No, we came out here.
Well, I need you to take care of that. That's at 10 o'clock. Listen, Tabitha,
We gotta do that. We got a guy in Monroe County Jail. He said we gotta get done.
okay, I know, but somehow there was an order on the McCullers files, and the McCullers files have to go to the Flat Rock. Oh, that's tomorrow, isn't it? That's tomorrow, isn't it? McCullers? Yeah, or is it today, Lisa? I don't remember.
That's tomorrow.
Okay, somehow we had an order on there.
A discovery order?
Pardon?
A discovery order?
Yes, but it wasn't on that case. It was on another.
Oh,
case. It was
okay.
actually put
that was
on.
my fault.
Okay, that's all right. I was thinking that was up today. Jose Luis Silva Murillo, 25W8390991A. Come on up here, sir. And B and C. I'm going to emphasize your name.
Eric Ward,
Can you spell your last name?
W-A-R-D.
Okay. And you're a Spanish interpreter, correct?
Correct.
It's got to be I'm getting tired of these guys. Get them interpreters, then they don't show up. Defendant failed to appear. I'm not just calling this. This is a willful intent to delay adjudication as far as I'm concerned. He was here once. I told him we'd get a interpreter. He didn't show up. And this was scheduled for 9:15. Bench warrant to issue. It was scheduled for 9:15 and it's 9:30. I thought these were scheduled. Was there one scheduled for 8:45 or not?
This one's for 8:45, Your Honor. The other one's at 9:00.
Oh, this is for 8:45, Lisa? Yes, it is. So he's 45 minutes late. Bench warrant to issue, bond to be forfeited, 3,010%. I'll just make a note. I called the case at 9:29. Thank you very much, sir. I guess you got to wait on the other one. I'm sorry. Oh, and by the way, I'm entering default judgments on B and C. Default judgments are entered for defendant's failure to appear on files B and C. So as soon as we can process the other one, I'll call that. Thanks, Mr. Ward. All right. Paul Edmonds. Paula Patricia Edmonds, 25W8390777A and B. All right, your name?
Paula Edmonds.
You got a valid license. He's reducing it to impeding and dismissing both the suspend and obstructed vision. You should have been a lawyer. You did a great job for yourself here.
Thank you.
To the charge of impeding traffic, responsible or not responsible. That's 0 points. It won't go on your record.
Am I saying responsible? I'm sorry.
I want to make sure that's what you want to do, is it?
Yeah, responsible.
So I'm going to ask you again, to the charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the suspend, dismiss the obstructed vision on motion of prosecutor 225. You can go right down the hall and take care of that, and you're all set.
Thank you.
Good.
Eric Ward,
Raise your right hand. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant
I swear.
and the parties here.
I swear.
Okay. And you're a certified interpreter, right?
Yes.
All right. This case been going on for a while. Your name? Okay. I'm ready to set it for trial. Does he want a jury trial or does he want a bench trial?
Your Honor, it's my understanding that my client is now suffering from pink eye and he would like an adjournment.
Listen, I want you to tell him this. We try to provide fairness here. You don't get to bring interpreters into the courthouse every time you come here. I will also remind you that I was convinced by staff that you actually can speak English, but I'm doing everything I can to accommodate you with an interpreter. This is it. We've had too many court dates. This isn't a murder trial. You were here June 25th. You were here July 9th. You were here July 23rd. And now you're here August 6th. We are either setting this case for trial today or it's being resolved today. If you have such a bad condition of pink eye, you can go out in the court, go out in the parking lot, and you can Zoom with your lawyer. I have no problem with that. If you called ahead, that's what I would have said. But I'm not going to keep adjourning this. These guys are charging a lot of money, and guess what? If there's a conviction, you're going to get to pay for it. So let's stop prolonging the case and either resolve it or go to trial. Period. You got it? I asked him if he understands.
I don't feel well.
Go out in the car. Go out in the car. If then we can just set it for a jury trial or a bench trial, as the case may be. I'm not going to keep. Taxpayers are not going to pay for these people to come in here. What do we get? $160 an hour, I think we're paying these interpreters. We're not doing this. So does he want a jury or a bench? I don't want to hear any more of your excuses.
Your Honor, can we recall this man talking to McNally? I didn't even have to talk.
He's always got an excuse, it seems like.
I know.
Well, you understood what I said, didn't you? You just shook your head. Hey, you just shook your head when I spoke English. You understand English. Don't play with me. I'm not a toy. Now go out and we're either setting this for bench, we're setting it for jury, the prosecutor's dismissing it, or there's going to be some other form of resolution today. Period.
Thank you, Your Honor.
Thank you. Julian De Jesus Isaac, 24-835-467.
Michael Crawford, representing
Your name, sir? All right, what is he going to do?
Your Honor, my client's going to be guilty to the violation.
Calling him the lead. If you plead guilty here, sir, your probation could be revoked and you could be incarcerated for the maximum provided by law, which is up to, on this case, 45 days, since there was a plea to an attempt. Do you understand that?
Yes, sir.
And did you sign the advice of rights and read and understand the rights?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge you failed to attend, or I'm sorry, register for the Positive Strategies program by July 18 of 25.
This bond ruling is actually more layered than it may seem at first glance. A $10,000 personal recognizance bond means the defendant isn't paying cash up front, but the conditions attached are very serious. Travel restrictions, zero contact with the alleged witness, and a total ban on entering Panera locations show the court's intention to protect the public while still allowing the defendant to maintain employment. Judges often balance risks with practicality, especially when a defendant holds a job and voluntarily appears in court. But here's the question. Do you think the judge went too light, too strict, or struck the right balance? These kinds of cases walk a fine line between public safety and due process, and every condition matters.
You plead. Did you fail to register for that program by then? Did you fail to register for the Positive Strategies program?
Yes, sir.
And you were supposed to do that in this case by July the 18th, correct?
Yes, sir.
Anybody force you to plead guilty?
No.
Plea is accepted. I'm going to get the probation officer in here, but I ordered him to do this back on March the 5th. He's had 4 prior technical violations. The first one was for failure to report to probation, failure to attend court work program. I didn't do much. 6 hours community service, $100 costs. The next one was for failure to attend the court work program and failure to enroll in the Positive Strategies program. That was on July the 8th. I told him he was going to register for the program by July 18th and serve 1 additional day on the court work program. He still isn't done. Your name?
Emily Casino.
What is the problem?
Well, Your Honor, it's been a financial issue. He just didn't have the money to register at the time, but since then, he has gotten together the money. He is registered. He's scheduled to start since September.
So it was the 7th of this month.
September, 7th of this month.
That's tomorrow.
Yeah, so the court just
Do
gives.
you have verification of that?
So when I emailed, which I met with him yesterday at noon, he told me he was enrolled, but when I emailed PRS, she emailed me back at 1:53 that he was not enrolled. So he lied to me, which I don't like.
You showed me.
But he-
You show your lawyer
He registered, he emailed me this morning, yesterday evening.
saying he has enrolled.
He now has.
Why are you playing games with this?
I can't even give you an excuse, to be honest with you.
Are you working?
Yeah.
Where?
It's a district.
What kind of business is that?
It's like, I'm arrested, safety rescue.
You're making things hard on yourself. How old are you?
So,
You gotta grow up. You gotta grow up. I placed him on probation for a period of 12 months on March the 5th. Time is not of the essence. So here's what you're gonna do. Because you're making us beg you, I'm not gonna, and I heard what he said about not having money. You're to serve 4 more hours of community service. It's time for you to grow up, son. And that has to be completed by August the 31, in addition to whatever other penalties I imposed. Come on now. I sometimes feel like a babysitter up here. I'll take a 5-minute recess, everybody. Stay seated.
And that wraps up a courtroom session filled with high-stakes decisions, strict warnings, and some very frustrated judicial moments. From felony charges involving hidden cameras to DUI bond conditions and defendants pushing the limits of courtroom patience, today's hearings showed how quickly cases can escalate and how firmly judges must manage their dockets. We saw PR bonds, travel limitations, mandatory treatment requirements, and even a bench warrant issued for failing to appear. Each ruling carried real consequences that will shape what happens next for every defendant involved. If you found this breakdown as shocking and fascinating as we did, make sure to hit that like button, drop your thoughts in the comments, share the video, and don't forget to subscribe for more geo-dropping courtroom breakdowns.